Good evening and welcome to Land Title Talk, where we encourage you to text your questions in at 904-501-4481, 904-501-4481. That is also my cell phone number, so just in case you want to text about anything else. Today we have with us, as always, my esteemed, fabulous, wonderful, intelligent guest. Just ask him, Rusty Collins from the law office of J. Russell Collins, affectionately known as Rusty Law. And we have Julie with us. Thank you, Julie. She's here to keep us in line with her laptop. So we're glad you're with us. You can listen live on the 904 Now app. Is that right?
Yes.
And how else? Why don't you just go ahead and
The Land Title YouTube channel and the Land Title Facebook page.
Awesome. She gets it right. I'll screw that up. Rusty, what's going on in your world?
Not a thing.
Good, because you know what I wanted to get to. So the last couple weeks, 3 weeks, I've given you heads up, which is not something I normally do.
Well, it's good to be prepared on certain subjects.
You know, I enjoy it when you're not prepared. It's actually, I find the spontaneity very enjoyable. But these are things that I feel like I just wanted you to be more prepared. I mean, call me a good brother. But I want to talk about homestead. It's come up a lot lately. It's actually, I shouldn't say a lot lately. It seems to always come up in our business.
It does.
There's always something pertaining to homestead. So let's just spend a minute and let's talk about that, because Florida is pretty unique.
Awesome. That's what it is. Florida's awesome.
Florida's awesome. Pretty unique on that homestead front, right? So let's talk about homestead. What in the flip is homestead? Because I can tell you, I ask you a question, you start answering, I interrupt you. Cool?
Yes, you did.
Do you want to try that again?
Okay.
So, no, I'm just kidding. So, because a lot of people think that homestead is only the tax exemption you get.
That's the benefit.
That's
but you have to apply for that.
But you have to apply for that. That's what I think most people believe homestead is. That's the discount you get on your taxes when you file your taxes.
And that
but
is
it's more
correct.
to it than just that.
That's right.
Okay, sorry.
So your homestead is a piece of property that you own and live in. And the exemption from the benefit to that is that property is exempt from creditor claims. The Constitution basically says that you cannot levy against the homestead for anything other than the real estate taxes, a mortgage, something that was purchased money, somebody who works on the property to improve it. And that's pretty much it.
That's pretty powerful stuff.
That's very powerful. This makes Florida the debtor's capital of the United States. But there's a size restriction. If you're within a city limit, a municipality, you have a size limit of a half an acre.
Oh, that's right. A half an acre. That's right. I'm glad I didn't open my mouth. I was about to get that wrong.
If it's outside the municipality, it is 160 acres of contiguous property. So you could have 3 different parcels.
But as long as they're contiguous.
If they're contiguous, it may not be homestead for you and the property appraiser, but it would be the homestead for
it's protected under the constitutional
provisions, right?
Of the homestead.
So that's
and we call it the Homestead Act. Rusty, is that proper?
I call it the Constitution.
Okay.
The
Homestead Constitution.
Right, the homestead provisions of the Constitution.
Okay.
Article 10, excuse me. Yeah, Article 10, Article 4, Section 10.
Okay.
Article 10, Section 4. Daggum.
It's okay. You deal with it only every day.
Okay, so, but there's some prohibitions. If you are a married person in the state of Florida and you live, or you have a homestead, and you own that homestead by yourself, you cannot do anything with your homestead without joinder of your spouse. Plus, if you have minor children, you cannot devise that property to anybody but your spouse or your children. Any other devise is not valid. And that's a big deal. So you can devise your homestead property if you have minor children to your spouse because she's probably going to take care of them. But outside of that, she gets a life estate. They get the remainder, and because the homestead not only protects the homesteader, but it protects the public at large.
And how was that?
Well, we don't want people to be wards of the state. We want to protect children from having to need certain services.
And we're going to get to the nuances because you covered a lot of nuances.
Oh, the dots of nuances.
Yeah, there's lots of nuances, but I want to get to some specifics.
Okay.
Let's talk about you're not in a municipality. So describe municipality.
City limits.
City limits.
So
Not-
in our county, it's probably St. Augustine city limits. I don't know. Is Ponte Vedra municipality?
Ponte Vedra municipality.
Okay.
Will you check that for us?
And
Yes.
it used to be Hastings, but now it's not.
No, Hastings, I don't believe is a municipality
Nope.
anymore.
They dissolved it. So
Right.
St. Augustine and then maybe
Oh, St. John's?
St. John's. I don't think it's a
I
municipality.
don't think it's municipality.
No.
So if
Ponte
you're
Vedra's
not,
not a municipality.
wow,
I didn't think so.
I would have argued that differently. Good thing we didn't bet on that one.
Yeah,
I thought it
'cause
was.
I think
I guess
the only
there's not. You're
municipality
right.
we have is
It's St. Augustine.
St. Augustine.
St. Augustine proper. So,
the city of St. Augustine. Their city limits, they're established.
okay.
District created to supplement services from St. Johns County, not a city or a town itself. So in itself a little bit different.
And municipality, town, same difference.
I say it's a municipality.
Okay. City or town's the same thing. Municipality.
Well,
It's an
okay.
unincorporated
Willaca.
community.
Okay. Willaca. Municipality.
town. Well,
No, it's a municipality.
Julie, look that up.
Right.
Difference between municipality, town and city. We'll have her look that up.
Willaca is.
The point is, half an acre.
Half an acre.
So if I have 5 acres and I live in a municipality and I
If you
get
have 5 acres in the city of St. Augustine, you're doing pretty good.
yeah, you're pretty well to do. But go with me here. Judgment's filed against me.
You have to designate a half acre piece. Everything else is up for grabs.
Okay. Interesting. All right, so I want to get into some specifics about homestead marital rights.
I don't necessarily think they're homestead marital rights. They're
I get it,
homestead legal
but-
disabilities.
Fine. Most people don't understand that terminology. I think most people would understand marital rights.
It's a disability. Okay.
You can go ahead and try to explain yourself. That terminology doesn't fly for people.
Because it's not, your spouse doesn't have rights.
No one's going to say my wife is a disability.
It's a legal disability. I didn't say the person's a disability.
I'm going to tell you.
You are disabled and you cannot sell your homestead without your spouse
I
joining
get it,
in.
but can't you say it's my wife's marital
You're
rights?
disabled.
It's my wife's marital rights. She has marital rights, yes or no?
She doesn't have any marital rights.
She
may
does have
some-
marital rights.
No.
Yes.
You have to get her. You're disabled without her signature.
I can't sell without her signature.
Not in most cases.
Okay. You can't sell without her.
You can
signature.
contract around some of this stuff.
I get it. Julie's texting me. Hey, Julie. Sure, you just don't want to say it?
Well, you guys are on a roll.
Okay.
So basically, a town is a small municipality. So municipality is a larger, broader term. It's kind of like an SAT question. One
Okay.
of these is not like the other. So a town is a municipality, but a municipality is not necessarily a town. But they
Great.
have their own self-government.
So it's chartered,
Yes.
and it is a municipality.
Yes.
Okay. So you call them a disability, that's fine. Spouse is a disability.
Well, I think the term
I think
means,
it's marital rights.
Well, the term means something.
Yeah.
Okay. Your spouse has no rights. However, she may have some veto power. Okay.
I so disagree with that statement. They are rights because you're not, if you have a property in which you reside,
Right.
okay, what determines that property being the property you reside in? What determines that?
Do you live there?
Okay, let's say that
And you plan to live there?
let's say that I have a PO box for my address and I use my driver's license as a PO box. Can you have a PO box for your address on your driver's license?
I don't know if you can do it now. I've seen them.
I've seen them. I don't know if you can either now.
Oh,
Hey,
I
Julie.
noticed.
We're putting you to work today.
Right.
Had to renew my driver's license, and my number changed
On your road?
on my driver's license.
Oh, your driver's license number changed?
Yeah,
Okay.
because it used to be a calculation. You give me your driver's license number, and I could tell you your name and date of birth, and whether you're male or female.
Oh, they got onto you, did they? They caught onto you. I mean,
And then now, but I also could take your name and date of birth and calculate your driver's license. So it's great. But now
those days are gone.
Those days are gone. Starting with
Doggone
renewals.
it.
Yeah.
Fraudsters
hopefully-
ruin everything.
Well, I guess I just feel like it was a great tool for checking stuff.
Okay, back to
Anyway,
cannot put a PO box.
No.
Oh,
You
so
must
that's
have a
changed.
No, well,
physical
It
well,
used to
well,
be.
well, here's the thing though. Your driver's license is supposed to have your residential address on it,
Right.
and most of us can't live in a PO box.
No. Most
Okay,
of us can't.
and
Yeah.
you have like 10 days from the time you move to change it. So,
storage unit number, maybe.
well, whatever.
So, all right. So a gentleman has a place. Let's just say he owns this house. He's always on the road. His driver's license shows the address of, let's just say, 139 King Street, for lack of a better address.
And that's not where Whetstones is.
It is. But I'm just using an address. I
Okay.
mean, come on. Because
Shout
I don't
out
want to
to
use
Whetstone.
I don't want to use your address. I don't want to use Julie's address, however we could. I just
It's public knowledge.
just the bogus address, because it's commercial property. I know I can get away with it. And I'm not sharing anybody's personal information. 139 King Street. My driver's license shows that I'm never home. Okay. I have a wife, but I only own the property by myself.
Do you own any other property?
Yes.
Do you rent the other property out?
No. I have, and I'm not saying this individual has a girlfriend in Tampa and a girlfriend in Miami. His spouse is in St. Augustine. He probably lives more at the Tampa address than he does anything. What is his homestead?
I don't know, but I would think if he lives there more.
Is
Yeah,
it where the
he-
driver's license is?
I'd say after St. Augustine finds out Tampa's his permanent address.
I mean, you think this is a farcical example. It is not.
Well, I don't know how I would determine what his actual legal homestead is. Yeah, if he's filing
When he
homestead,
dies, that wife lives in the other house, the one in St. Augustine.
Okay,
His driver's license has the St. Augustine address,
okay.
homestead.
Well, where's he getting homestead exemption?
He didn't file it because he didn't want any confusion.
Well, somebody's gonna have to determine where he lives. I guess you could say it's where his
He
family
lived in
lives.
Tampa, but I would say it's where his family lives.
I would think so.
Okay,
Now,
I think that would be, if you're defending the wife,
I would say that's where he established his homestead. That's where his spouse is.
right, even though he doesn't go to bed there. We typically, in our business, would state that's where the driver's license is and where they go to bed at night. That's pretty much what we determine, but that's not always so clear cut.
Well, you would have to establish. I mean, it's on our own. It's on the person needing to prove the truth of a matter to be able to prove it. Okay. You have to have the intent to make that place your residence.
His intent was to,
Have his cake and eat it too.
yeah. Yeah, but he didn't want anything in anybody's name because in his mind, he's trying to circumvent the fact that this woman's going to have any life estate interest. He actually has kids in different cities.
Well,
He wants the kids to get the property, not the wife.
well, good
Doesn't
luck
even
with
want his
that.
wife to have a life estate.
Okay, well, he's got to have a home somewhere. Okay.
Rusty, it's an interesting question.
I've never seen it litigated. I've never even attempted to find a case on it.
I don't know if there is a case on this story, but that poses a great problem because I can tell you this, the spouse will come to you and say, I want you to represent me and my rights to live here and to raise these children. I think that a constitutional homestead is going to be the house where she lives.
Probably.
I think that that's going to be the answer to the question. Okay.
That sounds reasonable, but the law's not always reasonable.
That's true. But I think this is one of those things where if you looked into it, which I'm glad I didn't give you the heads up on this one.
It's always, it also depends on why he died. If he died from his wife shooting him, then she died first. So that could change things too.
Yeah, that's not the story. Okay, but something happened to him in a normal way of life, whatever happens.
So but homestead's interesting because if you have your wife in a home in Florida and you legitimately live in Alaska,
Mm-hmm.
and that's where you live,
Mm-hmm.
and you own it,
Mm-hmm.
and and that's where you plan to live,
Mm-hmm.
your Florida property is not your homestead.
Interesting.
You can sell it out from under.
Okay. I mean, that might be the same problem with this gentleman who has the home in Tampa and Miami.
So,
I mean, she may not have any rights, Rusty, if that's
Well-
the case, because
well,
the
this
analysis is
but
still
now,
the same.
But now we only have this is all Florida.
Yeah, but still the same analysis. He's not living there.
If you have a homestead in another state,
He's going on the practice it's cheaper to keep her than to get rid of her. She's okay with the plan. She just wants the house. He's not willing to give it to her.
well, shouldn't have died.
He's not dead.
Yeah. Huh?
He's not dead.
I thought we were talking about.
What if he dies?
Okay, what if he dies? Okay.
Yeah.
Well,
No, if he was dead, she would have already seen you. You'd be talking about the story and bringing it up rather than me.
okay. Well, but I mean, there are things you can do to get around certain homestead rules. Okay.
Okay. And I want to talk about that because I have another story, of course, right? We have, I want to make sure I change the acreage because I don't want to sound too familiar because this is a real story too. So I should have written this down before the show, but I'll make up some acreage here. I'll make up some. We have, let's say, 4 acres, okay?
Okay.
4 acres of property. The scenario is we have a father and a son who own this property together as joint tenants with rights of survivorship.
Okay.
Father lives somewhere else.
Okay.
Father's claiming homestead somewhere else.
Okay.
Son is the only heir to father's estate.
Okay.
Son lives on the 4 acres.
Okay.
Okay. Son has 5 children. 3 of them minors. All 5 children are from 3 different mothers.
Okay.
Okay. The current mother of the infant they're getting married.
Okay.
He wants to protect the home from her being able to have life estate interest because he wants the children to be able to maneuver freely if he dies without having to have her stay there, primarily because she's only mother of 1 of the 5.
And we have minors.
We have 3 minors.
Okay.
Now remember, this is made up. How many minors we really have is different in the real world.
As long as we have one.
We have minors. Okay, I am changing some of the facts of the
I don't
story.
care- I don't care
want
if
anybody listening to this and say, "Oh, I know that story."
No, I
Okay.
don't. As long as we got one.
We have 3 in this
Okay.
story. We have 3.
All right.
Okay, for you, we have 3 minors. So here's the idea. Option 1, attorney told him to do this: set up a trust. Make dad the trustee. But I feel there's a problem because he's still going to have the homestead and he's still going to have use and he's going to be a beneficiary. Does that circumvent the marital rights? Sorry, I'm going to use that word. Okay, marital disabilities, if you're Rusty. The marital rights of his soon-to-be wife that he does want to marry.
Okay. Father and son own the property as joint tenants with rights of survivorship.
Correct. But if dad dies, son becomes the sole owner. If Son dies.
Dad becomes the sole owner.
No,
How?
dad's already dead.
Okay. Dad dies first, and then no matter what.
In this is a scenario, and they're both alive, but they're trying to plan. Dad expects to die before son. That's what any normal parent-son relationship would be, right?
Mm-hmm.
So, how does he protect the homestead from the wife getting the life estate interest?
Don't marry her.
Well, I did say that to him. So,
What's the reason for
just
getting married?
Take that out of there. He's going to marry her. Okay. That's just, you're not talking about that.
Well, then he's an idiot.
Okay. What can a trust take care of that?
The problem I'm having with it, and maybe I'm missing something, but is you cannot devise homestead if you have minor children, except to your wife or to your children. Or no, you or
Without
wife.
your spouse's joinder, but
Right.
he's not married to her yet.
I know. Okay.
So if dad and him create a trust and give it to dad as trustee of the kiss my butt land trust,
and the kids and the children are the beneficiaries of
No.
the trust.
he is.
But if he dies, the children become the beneficiaries.
Yeah.
That the plan?
Yeah.
When he makes the trust, he doesn't have the disability except to the children.
Can you trust that out? I told him I didn't think so, but that they have to come see you and pay you money to figure that out. I said, I'm free because I'm not giving legal advice. We're just talking.
The question becomes
You need a drink there, sir?
probably.
Isn't it one right there?
Yeah.
Is that
Oh,
yours?
is that yours?
Oh, I
Oh,
thought-
crap.
Okay.
Yeah, just drink that. I don't know who drank it.
I thought it was.
Here, Rusty, this is for you.
Okay, good.
Do you feel better? No? Okay.
No, not yet.
At least I tried. At least you gave it that moment to look something up.
Yeah, my first thought is at the time he does the conveyance into the trust.
Mm-hmm. He's single.
Right. So he's not disabled as a,
At that moment, he is
At that
not
moment.
disabled. He gets married. It's still his homestead, Rusty.
but the conveyance to the trustee
Yes,
is when he's not disabled, except
Correct.
except as to the children.
correct.
Okay. So
Okay.
the disability, I know that's a testamentary type trust. So I think I want to hedge on any answer, but my first thought is,
You're wimping out on me?
yeah, of course.
Don't wimp out on me.
My first thought is he can do it because he's not disabled at the time he does it.
Yes, but he's still the beneficiary
I understand.
at
but
the time
I know.
he dies. It's still his homestead property. You cannot devise your homestead property, Rusty. Because you know what's going to happen. He puts it in the trust. Who's the successor trustee, Rusty?
Not a spouse, I hope.
No. If its father is the initial trustee and the father dies, okay,
Mm-hmm.
who do you think the successor trustee is? You? No. It's going to be the son. Don't we have a merger of title issue?
Not with a trust.
I don't know. Beneficiary's the same. Trustee's the same. They're getting homestead exemption. He lives there. Is the trust going to work? You're great with podcast time sitting there.
Well, I'm looking at like,
Well, I'm glad I stumped the chump. I mean, that's great. I mean, this is a legit question that, oddly enough, now I told you this morning I was going to talk about homestead, right? This is actually a client that came in to see me this afternoon about this topic. Just happened to be the same time that we're doing the podcast. It was just sort of one of those magical things.
okay, so the word we use is pre-termitted. Pre-termitted
Terminated.
is a spouse or a child, but a spouse that gets married to the person after the item was made, like a pre-termitted will.
Okay.
Okay, so in a will situation, if you make a will before you're married,
Mm-hmm.
and then you get married,
Mm-hmm.
then because they were not part of it, they would get what they would get if you died intestate.
Testate. That's yes.
But under the probate code, you can explicitly exclude. If you say, if I get a spouse, I'm excluding them.
You can specifically dictate that.
That's correct. Now, if you.
But does that void their life estate? I don't think so. I'm going to have to get you to look this up where you have more time.
Yeah, you got me.
I love it. I love getting you. So that's that trust question is very important because that's what they were told to do a trust. And my feelings on this topic, Rusty, is I don't think you can alienate your spouse even in the situation of a trust if it's your homestead property. I can tell you what my title underwriter would require.
A lawsuit.
Well, no.
To go to a different underwriter.
No, if he were selling this property after his father died, we would require not only
You want the spouse to sign.
we're going to have the spouse to sign.
Right.
Okay. Why? Because we're risk adverse.
Of course.
We want to avoid any lawsuit. Okay. All right. So ADD man, we can't. We're gonna skip that option 1.
Mm-hmm.
Okay. Here's option 2. Okay. They to get out that computer. He just can't help himself. He just hey, over here.
Shiny things.
Yeah. Hey, I'm gonna bring a bell. So their way around this, they thought, would be is to just give the property to dad. Lose his homestead, give the property to dad.
Okay.
But then you still have the problem. When dad dies, who inherits the property?
Whatever dad's will says.
Dad's will is going to say his son, his only son.
Then he should do it to his son for life with remainder to the kids.
Can you still, in that case, but see, the son still wants the right to be able to sell and manage the property, just doesn't want a life estate interest. He wants to own the property.
I don't want to pay taxes ever again.
Okay, but my point is that doesn't work.
We're both disappointed.
Yes.
All right. So wait, why don't you just appoint a guardian for the minors and have the wife sign her rights away?
She will not
Oh, she won't.
sign her rights away. Yeah. She's not going to cooperate with this.
Who?
The wife, the soon-to-be wife. She's made it very clear. No prenup, no nothing. We're going to talk about that too.
Yep.
Then why are we getting married?
Because, put yourself in her shoes. She don't want to feel like something happens to him. She's out in the cold trying to raise this one child.
So, I mean, seriously. Okay, marriage is a contract.
I get it, Rusty.
Okay.
She's not willing to have.
She's not willing to negotiate.
She's
the
not
terms.
willing to negotiate the terms that requires her
Sound like
to
we have an
waive her.
impasse.
Well, we have an impasse with this thing, but he wants to get around it, so it's not a point of contention. Okay, you just do it to where, hey, you married to me. This is not even an option because we've contracted around it to where you never come into play. Okay. You happy now?
Almost.
Okay.
You can contract around these things, but you got to make it very explicit. I just need to make
Can
sure.
you contract around it without her acknowledgement? I don't think so, Rusty. And again, the problem is if he conveyed it to his dad, and then his dad dies, he inherits the property. It's now homestead. He lives there. That doesn't work.
He can make the son the trustee and the beneficiaries the children.
That gives him the rights to act. Actually, that's a very good idea.
I'll send you the bill.
Thank you. I'll send it to them.
But
make him the trustee, which gives him the right to maneuver.
I guess my question is why are we doing
Rusty,
all
that's
this
That's
stuff
a great question.
if we love this woman, but we don't want to provide for her.
It's not that, Rusty. He's going to provide for her. He just doesn't want. He's got other children. Rusty.
Life insurance takes care of a lot of those things.
Yeah, but he's got other children. Okay. How easy is it for a person who, when you go, the other, 3 children become not mine, right? He just wants to make sure that they're protected and they can maneuver. He's got other children that are older that he wants to make sure they're all taken care of. Okay. He doesn't want them getting left out where she just decides to hold up the property or hold it hostage. Because remember, she's got the one kid, right? So that's why they're doing it. But I like your idea. So, which is genius, Rusty. This is why we're going to send him to you so you can talk to him. Okay. But your idea is make the son the trustee and the beneficiaries of the trust being the 4 children. The 5 children, excuse me. Thank you, Jolie. No, that's why you're here. Yeah.
I'll send you the bill.
Yeah, thank you. Okay. Rusty. Does that make sense?
It does.
Would that work?
It should. I just want to
He's
make
going to
sure.
lose his homestead, though, right?
That's, yeah.
But there's the cost of doing business, which, by the way, is only going to cost him an additional $300 a month if he loses his homestead.
And we'll have no
Well, how much is
property
the child
tax.
support?
Actually, that's a very valid point.
Seriously, my biggest problem with the whole scenario is
I get it. Don't
when you get
caught
married,
up.
you make a contract with the spouse. You don't
Yes.
have any contract with your children like that.
Yeah, but he's got, for my story, again, the circumstances are really a little different. 3 separate women, and he has 3 separate sets of children, right? Okay.
Well, obviously, he needs to pick a choice.
Those 2 relationships didn't work out. He's with one now. Okay. So making himself the trustee and the children the beneficiary, then he can maneuver. He's just going to set up a checking account in the trust name, obviously, right? So I think that would work. I think that's a genius idea. Let me tell you something else they thought of. Man, I get him on something. He cannot get off of it.
Well, because the answer is a complex question.
It is. I'm giving you the right to answer the question at a later time. You don't have to keep looking for the answer.
Yes, but I'm fixated on stuff.
Yeah, I know that.
ADD, the drugs don't help.
No, and probably why you're a pretty good attorney too. But here's the other suggestion that worked out that they thought they would try. Ready?
Mm-hmm.
They take the 4 acres, and since it's rural, they would cut it up, leave 1 acre to him. Okay.
It's contiguous.
That's right. That wouldn't work. So, and that was something that I had failed to remember when they were giving me that idea. I'm like, I don't know. I mean, I might.
Wait, you got this 1-inch strip in between these 4 acres?
Yeah. Yeah. It ain't going to work.
Well, if you didn't own it.
Ain't going to work. Then you have an unqualified division, and then you invalidate everything for zoning
Well,
purposes.
Okay, well,
So,
what are you going to do?
Yeah.
Again,
Now, if it's across the street, maybe.
make a choice. Look, if they can't.
Well, I'm just saying. I just want to clarify.
Why would
that
you marry?
would not work.
Okay, but
Get off the marry thing. He's going to marry her. He loves her. He's concerned about the freaking 4 other kids that aren't hers. Okay, he can't get off that. She's concerned about the 1 kid that is hers, and she wants a place to live. He doesn't want the.
she wants to kick his wife out of the house.
No.
Mm-mm.
He wants the kids to be able to sell it and kick her out of the house.
And she gets.
Zilch.
Well, she would get.
But the minor kid gets
Actually,
it.
there's a calculation for how much a life estate's worth.
Yeah, but it's still negotiable. You can't force me to sell my life estate unless you do a partition action.
No, you can't do a partition action with a life estate.
Well, you can't force me to sell my life estate.
No, you can't.
Yeah, so you come up with the calculation. Who cares? I want $400,000 for my life estate interest.
Okay, well,
Yeah.
all right.
Right?
There is a way to. Well, usually what happens is the other ones want to sell, but
Right.
there is a calculation on how to do that.
So you can't partition a life estate?
No, because in order to do partition, everybody has to have the same type of interest,
Gotcha.
not the same
Actually, I didn't think of that.
percentage, but
Okay.
the same type. Life estate and
So they have
fee
they
simple.
have all the interest while they're living. There's nothing to partition.
Well, Right. They have all the rights to possession, but they don't have the ability to sell
Right.
too much.
Okay. So that whole idea of taking the 4 acres, taking 3 acres and putting in a different name, not a different name, but having a different deed, and that doesn't work because they're contiguous. Now, if it were in the city on 139 King Street, then you could take off.
You could set aside.
Yeah, you could set aside the other acreages.
You
And
could. But why not? You could
all.
also take the property and sell it and then buy some other parcels that you can actually divvy up before you get married.
Right.
So you have a homestead. You have these other properties that you own that you can own by trust. And then you have the homestead with your spouse. And then she still gets that.
Right. In a municipality.
Even as long as it's not contiguous.
That's the problem. This is contiguous. This property's been in the family for a long time. So, and the whole intent is for the son to get it from dad.
I'm not sure that you can't actually specify that this contiguous property is not my homestead. I don't know if you can do that or not.
Well, there's several things I want to get to, and our time's running short. But I want to cover: is there a way for you to have a prenuptial in reference to your homestead property where the spouse has no marital rights? Can you predetermine that?
Yes, you can. You can do it by
Okay.
contract.
So talk about that for just a second.
Okay, so you have the ability to waive rights, including certain constitutional protections. Okay, so when your children can't waive it because if they're minors, okay, because they don't have the ability.
Yeah.
But if you get a prenup, you can make those contractual provisions prior to marriage. You can also get those contract provisions after marriage, but you have to disclose your finances. So the guy that has a bunch of money somewhere else,
He has to disclose it to his wife.
yes,
Okay. Or
Okay.
vice versa.
you have to disclose it to your spouse.
So before the marriage, you don't have to disclose it.
Not as much.
Hey, we want to get married, but you're gonna need to sign this prenuptial.
Right.
You're gonna waive your rights to my homestead property was in a mansion on the ocean. I have 5 other kids before I married you, or before we're gonna get married. Sign off. He can mortgage that property, sell that property without her joinder.
That is correct. Now, the problem is going to be, of course, with the title companies being able to close. The underwriters aren't going to like it because you see, that prenup's not been tested yet, has it?
Not that I know of.
Well,
It's fairly new.
How do you test a prenup?
Court.
Yeah.
Yeah.
Who
wants to win that prize?
Well, when do you go to court?
When somebody
prenup.
challenges it
When do they challenge it?
at a divorce.
Right. So, there you go.
Yeah, and this got instituted, 2000?
Okay, so here's the thing.
It has not always been the rule. Don't give me that.
Yes, it has.
No, it hasn't.
The problem has been we had some courts doing some different things.
Okay.
Okay. It was like like a deed. You could use a deed if I own a piece of property with my wife, and it's our home, and she's going to deed it to me. We're going to do a deed together to just me.
Okay.
Okay. The question was, does that by itself? Why would we do that? Okay. Because we're giving up all kinds of rights by doing it.
Right.
Can it be inferred that by doing that, she gave up the ability that I lost my disability? Okay. Because she's giving up anyway.
She gave up her marital rights. Just say it.
Okay. Well, basically, she's pre-signing anything.
Right.
Okay. By signing the deed with me to just me on the homestead. So it was kind of like, did it work? Did it not work? We don't know. Okay. What does the court say? So court says one thing, and then another court says another thing.
Right.
So the best, courts interpret Constitution and statutes. Well, they solved the problem in 2018 by making a statute.
Okay.
Okay. And the statute gave some language that, when you think about it, it's kind of obvious. That if you put on a deed, like a deed, a spouse waives his or her rights as a surviving spouse with respect to the devised restrictions, not marital rights, devised restrictions.
I get it.
Under the Constitution, if the following language or substantially similar language is included in the deed, by executing or joining this deed, I intend to waive homestead rights that would otherwise prevent my spouse from devising the homestead property described in this deed to someone other than me. Now, what's nice is, though, that waiver is not a waiver of protection.
Doesn't waive homestead protection.
That's correct. For creditor
But
claims.
it takes care of waiving the marital rights.
Such language may not be considered
use
as a
it again.
waiver. Well, here's the thing, though. That is only for devise.
Mortgages devise.
No, that's alienation.
Okay. No,
In
you're
fact,
right.
the
No, you're
statute
right.
says
You're right.
this
You're right. You're right.
language
You're
may
right.
not be considered a waiver of the restrictions against alienation by mortgage, sale, gift, or deed without the
Wait.
joiner of the owner's spouse.
Oh, really?
That's the language of the statute.
Well, then, frickin' Jane, it doesn't do what I thought it did.
It's about devise.
I guess you just
This
have
is
to
part
read.
of the probate
I guess
code.
you just have to read the whole statute, then, huh?
It
You know,
usually-
I like reading to the point where it makes me happy and I stop reading.
yeah, that gets you in trouble.
This is why you're the attorney, not me.
That's why you don't read just like the head notes on in a case,
Yeah,
because there's other stuff that goes around it.
right.
It's a good way to start, but not a good way to end.
Okay.
So it's for estate
So
planning.
even when I have a gentleman who has a wife who signed off for marital rights, they're separated. She's off in Egypt somewhere. He can't find her. That doesn't change the fact that I have to get her joinder.
or he has to move to a different house to establish a new homestead and then sell it.
Okay. Okay. No,
Make
hey,
something
valid
else your
point.
homestead.
Yeah, making that your homestead. Right. Okay. That's a interesting point. So, gosh,
Just
we're
get divorced. If you can't find her, there's ways to get divorced.
it's funny how many times it's not funny. It's interesting. I'll use that word. How many times I've had people use that excuse. I can't find them. That's why I didn't get a divorce.
But you can get jurisdiction over somebody you can't
Do you know,
find.
I bet you in my real estate closing life, I have to have heard that at least 3 times a year.
Well, it's
At least,
more
if not
expensive. It's a house, so you've got to do due diligence. But we serve people often that we can't find.
More. Right.
All we want is jurisdiction. But one of the problems though is that house a marital asset? And just because
That's a
it's
whole
owned-
nother issue.
But if just because it's owned by one person doesn't mean it's not a marital asset.
Okay. So,
The most
listen,
the
I
most
don't want to get.
powerful court in the world, or at least in the United States or Florida, is the probate court, of course.
Divorce.
Or not probate court, but bankruptcy court and family court.
Okay.
I don't care how you hold it. If
I
it's your
don't-
asset, it's up for grabs.
I don't want to get caught up in this because I really want to talk about some other things about homestead. I own a house, 10, 15 years by myself. I'm a single man. I finally get married.
Oh, well.
Is it a marital asset? Marital asset now? It's not homestead.
It can become.
Let's say it's
okay.
it's
In
not-
the
it's
big
not where I
picture.
live.
Okay.
it's not where I live.
Right. In the,
Investment property. I have people paying rent every month.
okay. Right. In the big picture,
Mm-hmm.
if the house is worth $100,000 when you get married,
Okay.
you get divorced, it's worth $200,000.
The $100,000 during the marriage becomes marital.
Unless you did nothing. My way of explaining it better is when you get married, you have $100,000 in IBM stock. During the course of the marriage, all you do is cash the dividend checks. You get divorced, it's worth $200,000. There's been no marital effort. It's yours.
Okay.
If you have $100,000 in stock when you get married,
Okay.
and during the course of the marriage you buy and sell stock and you get divorced, it's worth $200,000. The first $100,000 is yours. The second $100,000 is a marital asset and will get split.
So an example of a commercial property, and again, I'm sorry we got off on this because this is a whole nother podcast. If it's a commercial property and she doesn't work there, I work there, I maintain it, I collect the rents, I do everything. That's not really.
That's marital effort. Everything you do
I get it.
from
I
the
get it.
moment you enter
get
in the
it.
contract of a marriage,
I get it.
everything you do is marital effort.
Gotcha. But the first 100,000 is mine. The second 100,000 that
Is
it
up for
increased
grabs,
is
yeah.
up for grabs. Okay, makes sense.
Okay.
Would that be the same for a homestead property?
It should be, because
Okay.
again, it's where you live, but
All right.
where's the values?
So let's move on to homes. What I wanted to talk about homestead, intestate succession, and wills. They're two
Okay.
different things.
Yes.
Okay. So we have a homestead property, and I want to go back to this joint tenancy with this father and son. How detailed would the courts get on this if the father and son were in an accident together? Okay, and let's change the scenario here. Let's say that the son has two sisters.
You got siblings.
Yeah, okay, the son has two, so he's got two sisters. They own it as joint tenants' right survivorship. They both get in an accident together.
Who
Dad's
died first?
dad,
No, there you go. Sons.
the son's
If
property.
you can now,
And the son dies the next day,
if you had that much evidence,
right?
and we're talking about intestate succession,
Intestate succession.
okay? Because a lot of wills say the person survives me by 30 days. Okay.
Oh, really?
Yeah.
I have not ever seen
Here we
that.
go. But in this case, we have joint tenancy.
We have joint tenancy. It's not. It's
Okay.
not a,
And
not a
we've
will. It's not-
established
yeah.
that dad dies in the ambulance on the way,
Yep.
son dies tomorrow.
Yes.
Son inherited, or the son was the survivor.
Son gets it.
the son
Sister's
survives.
getting nothing.
Right.
If it's the other way around,
Then I think
all three get it.
if you establish that, yes, because the son dies first, the father owns it, and then the three siblings own it, and it'd be the son's estate takes his third.
His third. Okay. So on a homestead property, it's clearly their homestead. He owns it by himself. Okay. He has a minor child, two adult children. The minor child is from his current wife, who is still living, who inherits the property if it's homestead. Intestate succession. You should have think that hard.
Okay.
That's an easy one.
Okay, you
I
say
threw you softball. You
okay.
got distracted.
Okay,
That was
Yeah.
I lobbed that one to you.
Spouse gets a life estate.
And
The children get the remainder.
okay, what about the minor?
He gets remainder.
Okay, what if there's more children? What if he has two children from another marriage?
They get their
1/3.
they get the third.
Okay. What about in the situation, and this is just interesting, right? Homestead property. Dad has a will. He's estranged from his wife.
He should have estranged to a divorce.
Not divorced. Matter of fact, he's frankly pissed off. And in his mind, that minor child is not his. Never did a paternity test, doesn't know for sure, but he's expelled them from the house. They've moved out. They're living somewhere else. He does a will, says, my two older children get this property, period.
That will's he dies intestate.
He died testate. He has a
No.
will.
He died intestate.
All right, explain yourself. You're using attorney language. He has a will. He
right.
died testate.
Unless you cannot devise
I get it. He still died
That-
testate. He still had a will.
that the will's tossed.
Will doesn't matter. Because?
He has a minor child. We're talking about homestead.
So who gets the property then?
The estranged spouse will get a life estate,
And
and the three children will have the remainder interest.
third. Okay. What could he have done?
Got divorced for one.
He didn't do that.
He could have willed the property to his estranged wife, but not a lot he could do outside. You're disabled, okay? It's going to the wife and the kid. All right.
Well, this brings up a title insurance story that I told you before. And if you've ever spoken to me about intestate succession and title insurance, you've heard the story before. So those who have heard the story before, I apologize. But we have a situation that happened to land title. A nice woman came to our office and said, "Hey, I have my property sold." I can't remember the numbers. Let's just say she sold it for, I don't know, $300,000, just to keep the numbers easy. Okay. She sold it for $300,000. We did our title search. What did we find? We found Dad. Dad owned it. Dad died intestate. Had no other children. Order determining homestead, which is,
The greatest probate document in the world.
which says
It says when Dad died, she became the owner.
she became the owner. Okay. Came to us with a beautiful contract. Real estate agents involved, realtors involved. Everything clean. So we gave the buyers title policy for $300,000.
Okay.
Okay. Daughter took that $300,000 and bought a house. So she took her $300,000 and bought another house. Year and a half later, I get some real irate buyers. Or I should say at this time, they're not buyers anymore because they already bought the house. I get some real irate insured policyholders. They were being sued. An LP was filed against the property from none other than 68-year-old dad, 24-year-old girlfriend who got pregnant and had a child, who did a paternity
Okay,
test.
so Daddy
and
was dead.
Daddy's dead.
Well, you said 68-year-old dad.
Well, and just there's just the fact that we
Oh, he was 68 years old and
when he died,
Okay.
yeah, and he had a girlfriend,
Uh,
and 60-year-old, yeah, he still worked,
fertile octogenarian.
I guess. And they did a paternity test. Guess you can check all that stuff out with medical records, I guess. I don't know. I'm not that smart. Prove that that child was his.
Dad's. Okay.
So now what do we have?
Title claim.
Yeah, we did.
I think you got a problem. That's what
Okay.
title insurance is for.
This is why you get title insurance.
That's the real
Because
reason we have title
you
insurance.
betcha, because no matter how we looked at everything was clean.
Well, yeah.
Everything was beautiful.
Yeah.
But you can't detect that. You can't find that.
Well, we don't have any bastard laws. So outside of being a bastard, there are no bastardy laws, which means a bastard or a illegitimate child has the same rights as a legitimate child. So doesn't matter. Not old England. It's not.
Just love the way you say things. So we have a title company. So what did the title company do?
They paid a claim.
They did. Roughly the mother just wanted money.
Of course, they bought her out.
They bought her out.
Of course, set her up.
Roughly half of the value of the sale.
Except how that child's still a minor, so I guess it was for the benefit supposedly.
Yeah, she got about 150,000 roughly. I can't remember. What do you think the title company did?
They went after the sister.
The daughter, the
Daughter.
sister. Yeah,
The question is, did she know?
she did not know.
Hmm.
But she still signed what, Rusty?
Well, warranty deed.
She signed a warranty deed, so she was liable.
She warranted the title
She was.
back to Adam,
She did.
and that's what it is. So if you inherit, don't give warranty deed then, huh?
No, if you inherit,
Get a
get a
title
freaking
policy.
title policy.
Yeah.
Because she didn't know. She had no knowledge of this event. And so now she owns a house.
The question was Daddy a bastard? Because if he was, maybe you should have title insurance to insure you just in case.
Always get title insurance. Now they filed a judgment against her.
Yeah.
This title underwriter has a final judgment against her
Well, yeah.
for $150,000. Again, the numbers changed.
That's unfortunate.
It's very unfortunate. She's livid. This has happened a couple times where my clients, I've always told my clients, you get title to a piece of property, you get title insurance. Because you don't have knowledge of things that have transacted. You just don't.
And then here's the thing: if you had knowledge, the title insurance doesn't protect
work.
you. Right.
We've had situations to where you have an individual who gets a deed, closing, warranty deed, and they're just getting a discount of a lifetime. And I got a warranty deed. I didn't get title insurance because the guy, we just pay him cash and we assume that mortgage that was against the property, and we're just making payments. And they turn around and they sell it. They pay off the mortgage, and they gave a warranty deed. But we didn't need title insurance because it was just cash and for keys. And come to find out, the seller was a fraudster.
Oh, yeah. And guess what? They didn't have any title.
They didn't have any title.
A fraudulent deed conveys nothing.
Right. So they are liable.
There's no such thing as a good faith
Get it.
purchaser for value.
Freaking title insurance policy on everything you own. Just get a title policy. It's inexpensive. Unfortunately for us title people, we don't get to bill you every year for that policy. You pay once and it covers you. There are legitimate, real reasons why you should have a title policy. And
it covers you forever unless you give out a quit claim deed.
but then you don't have any liability anyhow because you gave all interest out of any. There's no liability for that.
So maybe she should have used a special warranty deed.
Well, then again, you still have to prove that you had the rights. Even the warranty, in the special warranty deed, she's still warranting that she has 100% of her interest.
No, she's saying I haven't screwed up the title.
Rusty, I'm going to tell you that when you sign a special warranty deed, you're basically saying, I'm only going to warrant that which happened during my ownership.
Well, I guess she didn't have any ownership. I don't know. I have to look to see if you're saying you have
I'm just
ownership.
saying that when you sign a special warranty, you're still saying you have something.
I think you're probably right.
Yeah, you still need. The only time you don't really need a title policy is if you're going to give a quick
Is
claim
if you're
deed.
dead.
Or you're dead. Yeah. So it's just some interesting things. Okay. So when somebody dies and it's their homestead property, do you have to probate that property?
Depends on what you mean by probate.
Well,
No, when you don't probate property.
just quit being so technical.
All right.
Help me here. Person, homestead property, they die. What's the steps?
You need a judicial determination that that property was the person's homestead, and when the person died, the property passed by operation of law to these people.
If I
If
have
there's
a will,
you have to have the will admitted to probate in order for it to be considered valid, or at least judicially considered
if
valid.
that's the only asset they have, it's a simple summary administration, open file in order to determine homestead.
Right. If you're in St. Johns
But
County or
here's the
Putnam
thing,
County,
Rusty.
you
Here's
can
something
skip-
that you've blown my mind here. If I have a minor, if my will states anything other than that minor gets their, in this case, there's 3 kids, 1/3, that will's no good.
That's correct.
If the will says the child gets their 1/3 interest in my estate, then we're good. The will's still valid.
Yeah, we're not devising homestead outside the law
Okay.
requirements.
But by virtue of that will and by virtue of homestead protection, we can't alienate the spouse at all. The spouse is going to get a life estate interest whether or not I put it in the will.
Unless they opt for a half interest.
Well, they can opt for a half interest.
Yeah, but they got to make that option known really fast.
All right.
like-
So throw that out there real quickly. What does that mean?
Okay, so with intestate succession, if the spouse, if all the children come from the same 2 people,
Yes.
she gets it.
She gets half.
Well, if we don't have minor kids, she gets the estate, or she gets the homestead.
Okay. So you're telling me that if I have a husband and wife, they have 3 children, all 3 children are from that marriage, and I die, or the husband dies, the wife gets everything.
Right.
If there's minor children,
The easiest way is really simple.
the easiest way is really simple.
Yeah, the word keep. There's a flow chart.
Did you just say that?
Yes, it is very simple. Okay, was the decedent married when they died? When he died?
Yes.
Okay. Did he have kids?
Yes.
Did the either spouse have children outside of the marriage?
No.
Everything goes to the spouse.
Okay. I actually thought, okay, whether there's minor child.
You can't devise, but it would go to the spouse.
Okay. So the minor child.
If you have a minor child and a spouse, you can devise to your spouse.
Okay. The spouse has to elect that though.
No, you can devise, mean a will to your
Okay.
spouse.
Okay.
Okay. Or you can will it to your kids, but you got to provide for your spouse with a life estate.
Gotcha.
Okay, you can't do anything but that.
Gotcha. Okay. So
Okay.
you have minor kids, and I have a will that says my wife gets everything.
That works.
All right. So
And if you, the key here is, do you have any? Are there any other people running around the world with your DNA? Okay. If either one of you got DNA and other kids that didn't come
all
from
right.
the
So
spouse,
let's
then you're-
let's cover this quickly then. Homestead property. I have a minor child from 3 different marriages. I'm currently married.
Minor child from 3 different marriages. How'd that happen?
Okay. How about I have
Was it a triple? Triple?
I have 3 minor children from 3 separate relationships. I'm currently married.
Then you need to be neutered.
Okay. Give me what's the answer though?
Well, who are you married to?
The woman with the last minor kid. There's 2 other minors out there with other women.
You must provide for the minor children.
So third and life estate.
That works for me. Yeah,
No, is that the law?
I believe so.
Okay. Let's say homestead property. Gentleman dies. Never married. No kids.
Goes to the lawyer. Okay. It goes to, then you go through the, if you can't go down, okay, you can't go down the leaves.
Down line.
You can't go down line. You got to go up line.
Okay.
You go to the parents. Parents are dead?
Okay. Yes.
Okay. Well, if the parents were alive, they would inherit.
Okay.
If the parents are dead, then you got siblings.
Okay.
If you have siblings but they've died, then you got nieces and nephews.
Okay. Let's
You can
complicate
keep
this.
on going down.
Let's say I'm the only child. Parents are dead.
Okay, then we go up to grandparents.
Grandparents are dead.
Did they have kids?
Only one.
He wins. She wins.
Are there heirs?
And the uncles, it goes down, uncles and aunts. Okay.
What parent though? What grandparent?
What do you mean what grandparent?
Well, I guess so
You have parents.
you have
mom
parents.
and dad.
Mom and dad, they each have their own parents.
Right. Well,
Okay,
then
they're both
we
dead.
got 50-50. We got 50-50 now. Right.
Okay.
We'll go up there now. If we
I
don't
got
have
you.
anything,
I got you.
then it can go to one side.
I got you. So 50% is going one side, 50% is going the other side.
Unless we don't have a side, yeah.
All right. Well, unfortunately, we are out of time. We could talk about this all day. We really enjoy and appreciate you listening in. Text us anytime at 904-501-4481. I am the owner of Land Title of America. We are a title insurance company here in St. Augustine. I opened my company back in 1979, but we've been in title insurance, golly gee, man,
Since 1979.
since 1979.
And I was the first Collins in the title
In
business.
the title business, yes. So we would love to
16
help
years
you.
old.
We'd love to help you. We do all types of real estate transactions, commercial, residential, types of mortgages, all those types of transactions. We'd love to be there to assist you in your real estate needs. And most importantly, ensuring those transactions so that you don't run into the risk of having to pay this guy. He's pretty
Or some other blood-sucking lawyer.
or some other blood-sucking lawyer, instead of having a title insurance policy take care of that for you. So appreciate you having you. Rusty, how do they find you?
904-829-6600.
904-829-6600 is how you find Rust-Oleum, also known as Rusty Collins, affectionately known as Rusty Law. And you can reach us at our office at 904-797-9600, 904-797-9600. Again, thank you very much for listening. We'll see you the next time.